Adya, you can start introducing, sir, and then we can, yeah.
Hey everyone, I'm Adya Desai, student coordinator of the third GNLU workshop on law and economics. And it gives me immense pleasure to extend a very warm welcome on behalf of Gujarat National Law University to all of you today for the very first day of our week-long workshop on law and economics from 12th to 18th September. I now take the opportunity to introduce Professor Ram Singh sir, who will take the very first session today on law and economics, theories and applications from 4:45 to 6 p.m. Professor Ram Singh completed his PhD in economics from Jawaharlal Nehru University and his postdoctorate in economics from Harvard. He's currently a professor of economics at Delhi School of Economics, University of Delhi. His research interests and specializations include contract theory, law and economics, public-private partnerships, infrastructure, property rights, and law and economics in India. Professor Ram Singh is one of the most eminent scholars of law and economics in India, and we are glad to have him here with us for this workshop. Now, if I may, please request Professor Ram Singh sir to begin the very first session of the workshop.
Thank you. Thank you, Adya, for very kind introduction. Just give me a minute or two to make sure that my slides are in order. So please confirm that you can see the slides. Can you please confirm if you see my slides?
Yes, sir, they are visible.
And also I'm going to move them up and down. So please verify you can see them move as I move. So can you please read for me what is the slide title you see?
Sure, sir. It's Eminent Domain, Ancient Foundation.
Very good, very good. Now we are all set. Thank you for having me speak to you as a part of this conference. And I also heard that this is the first session of the workshop. So to that extent, it's even a more privileged privilege to be interacting with you. I'll be delivering several lectures during the course of this workshop. Today's lecture and tomorrow's lectures are going to be on eminent domain. Today, I will cover the basic legal principles behind eminent domain in Indian as well as international in more general setting. I will also discuss its economic rationale. And in tomorrow's lecture, I will discuss Indian version or Indian legal position on eminent domain. So we have today we have about 75 minutes in all. You are very welcome to ask questions during the course of this lecture. So try to ask only explanatory questions. If you have views, in this lecture I will draw some inferences, and if you want to dispute those inferences, those conclusions, you will be very welcome to do so. But please try to do so at the end of the lecture. During the lecture, please ask only explanatory questions. Let me see if I can make it full. Right. All right. Okay. So eminent domain. Somehow the slide got stuck. Just a second. I'm still around. Just trying to move the slides. I find my slides stuck. Okay. So eminent domain or expropriation laws are a body of law that gives power to government and government departments, government agencies to take away private properties, land or other form of private property. To start by a context which is in contrast, imagine a situation where you own a parcel of land or you own any property, residential, commercial, doesn't matter. You have a property owned by you. If I want that property as a private individual, then I have to pay you. I have to approach you. I have to check if you are willing to sell that property. If you are willing to sell, I have to offer you a price that is acceptable to you. Only after offering you a price that is acceptable to you, I can take possession of your property. I can take legal ownership of your property. That's what happens when a private individual wants property of another private individual. But if a government needs your property, then government does not need your consent to get your property. So forget about your entitlement to sell a property at a price of your choosing. Not only that you don't get price that you will demand, you want to demand your consent to sell or not to sell the property is not important for the government when government wants your property. The consent is not important. So in a sense, it is a very immense power given to government agencies when it comes to private property. This power may not seem very intense in some settings, but in several legal orders, for example, continental Europe, Germany, and other countries, property is taken to be part of a fundamental right. At the time of independence, we also started by declaring property as a right to property as a fundamental right, something that is very important for human existence, for humans to fulfill a meaningful life. Property is considered to be very important, and in those situations, in those contexts, giving so much power to government agencies to take away property without consent is a serious business. And the name, actually, the eminent domain has a foundation from that legal viewpoint, that it is the state that has preeminence over property. The property rights of private citizens are subservient to the preeminent rights of expropriation for the state agencies. So while eminent domain gives absolute power to government agencies, it also puts obligation on government to compensate the owner. So property owner cannot refuse to part with their property if government comes declaring the need for taking over the private property. But most legal orders entitle the owners to get some compensation. Also in many legal orders, there can be legal dispute over compensation amount, in the sense that government offers you some compensation and you are unhappy with the compensation offered. In that case, you can go to a court of law and demand higher compensation. So this setting or the legal principle of eminent domain is known differently in different countries. Popularly, we know it as a land acquisition law. And in USA, partly UK also, it is known by eminent domain. Though in UK, it is more common usage is compulsory purchase by the government. And expropriation laws, so it is known as expropriation law in continental Europe. But most rest of the world uses one or the other of these terms to describe eminent domain law. So the basic idea, basic motivation behind this legal position is that government takes away private properties only to fulfill common purposes, only to provide common good. And private rights, private interests should not come in the way of common good. Private ends or private interests should give way to the common good. That's the idea why most legal orders give this power, such absolute power to their government. And in terms of its ancient foundation, in lecture tomorrow, I would like to urge you to look deep into the Indian foundation of eminent domain. But when we talk about eminent domain in contemporary Western intellectual sphere, then its foundation can be traced to Magna Carta that was written in 2015. And basically, the Magna Carta is a document that is supposed to be protecting private citizens from the state, which is from the king, power of the king. It was supposed to be a protection. And in Magna Carta, so one of the provision is that no free man shall be taken or imprisoned or be disseized of his freehold, meaning thereby the property owned by private citizens, they cannot be divested of their property without following the law of land. So basically, so the ancient or medieval motivation behind eminent domain law is to protect property from the state. That was the initial motivation. But things turned around, and eminent domain laws have come to give absolute power to the state and its agencies. So now the principle is that the state has preeminence, supreme lordship of the state exists vis-a-vis all property under its jurisdiction. So then we have subsequently, in other writings, also it has come out that it is the right of the state to use and even alienate and destroy private property, as long as end is public. So as long as state is claiming to be taking over private property for public purpose, that is absolutely justifiable. That is what leading jurists have come to argue. So to sum up the discussion, today the way things stand, the law of eminent domain, the power vested in the state under eminent domain is to be used for public purpose. At the same time, affected owners should be provided just compensation. Just compensation. As a matter of practice, however, government agencies use eminent domain law for their own projects and also projects that are sponsored executed by private companies as well. So, but the two salient features are that they have to argue that project is in public interest and owners are entitled to just compensation. Okay. At this point, then we have to ask a question: what is the meaning of public use? Because the law eminent domain power is to be used for public purpose. So what constitutes a public purpose? One way of looking at public purpose could be that we can say a project serves public purpose if it serves community at large. For example, if we think of road projects, schools, hospitals, projects, such activities, projects provide general services to the public, and such land taken for such projects can be treated as a public purpose acquisition. Then the next question would be, how do we define just compensation? So to answer the question of just compensation, I ask you to think of a role of a property owner. Suppose you own a property. Suppose your farmland is being taken away for a road project, or your house or shop is being taken for an urban development project. What compensation you will consider just compensation? One way to look at just compensation, one reference point could be your valuation, the value that you put on your property. If you are paid compensation that makes you indifferent between that compensation amount on one hand and property on the other hand, then we can say that the compensation is just compensation. Remember, under just compensation, you are indifferent on getting money and giving away property, or alternatively holding on to your property. You feel equally good. You feel equally good in these two states of affairs, and from that viewpoint, we can call compensation to be just because you have not been harmed in the process. However, no legal order interprets just compensation according to this criteria. Most legal orders go by the market value principle. In other words, a compensation is called just as long as it is equal to market value of your property. This point we have to ask, is market value compensation just compensation? How do you feel getting market value of your property? If compensation you get is market value of property, then you will end up worse if government takes away your property. Why you will end up worse? Well, the answer is simple. Because if you thought market value of your property is greater than the value you assign to your property, you would have already sold your property. The fact that you are holding on to your property, the fact that you have not sold your property, this itself is an evidence that you value property more than what market offers to you. Therefore, compensation equal to market value is not going to make you whole, is not going to be full compensation. It's going to be less than full compensation. At this point, I'm okay pausing and checking if you have questions, any conceptual clarificatory questions. Do ask if you have.
So can you clarify what is different between the market value versus, like, generally we have a gentry value, no? Based on the land area, they determine the price. So that is
Sorry,
not
come again, market value versus?
like, I don't know what is there in Delhi, but in Gujarat, like, we have specific area. It is called jantri rates are differ from place
I
to
see.
place.
Okay,
And
I see.
market value include the legitimate price also, and something which may be on cash, which is illegitimate, yeah, maybe parallel money also, something like that.
Okay, so let us, this is interesting question. So let us take one issue at a time. Let's define market value of property. Market value of a property is that price that your property will fetch if you put your property for sale on the market. If you list your property saying that this property is on sale, the maximum price you will get will be called market value of your property. That's what I mean by market value of property. That is the meaning of market value of property in spirit under eminent domain law. So hypothetically speaking, if you listed your property for sale on market, the maximum price it will get is the market value. That is the understanding, that is the legal understanding. Now the problem arises is that we are talking about properties that government is going to take away, or government has taken away. The government could be panchayat, municipality, it could be state government, it could be PWD department, it could be department of central government. So government is broadly defined here. So we are talking about properties that have been taken away or will be taken away by a government agency. These properties are not going to be listed on the market. So finding out market value of such property is a counterfactual inquiry. Because if these properties were listed on the market, then we would know the market value, market price. But these properties are never going to be listed on the market. So how do we go about? So that becomes more of a logistical issue. In all countries, ours included, in all states, when it comes to assessing market value, some logistics, some rules are followed. One such rule is one such reference point becomes what are called circle rates or registry rates. So cities, municipalities, state governments across the country, they have registry rates. So I'm going to take a step aside. So let's take a step aside. Think of a situation where you and I engage in a property transaction. There's no government. Now think of just you and I. You are owner of property. I want to buy your property. I have offered you a price acceptable to you. You have accepted the payment. Therefore, I want the property to be transferred in my name. For this purpose, we go to registrar's office or tehsildar's office. We go to office of a mid-level state government officer. Now, that office has rates for different areas under its jurisdiction. Those rates are popularly called registry rates or circle rates. So why those rates are important? Because when we transfer property, your property in my name, then we have to pay a stamp duty or a tax. That tax is computed depending on where the property is located, and circle rates or stamp duty rates or registry rates applicable for that area. So the basic idea behind registry rates, same idea, registry rates, circle rates, or stamp duty rates, is that state government or municipality wants to collect tax over property related transaction. Those rates, even though their motivation is different, those rates are used in the context of eminent domain also. For example, in Ahmedabad, if your property is located in Ahmedabad, then the municipal commissioner of Ahmedabad will use circle rates to compute market. They compute value of your property depending on those rates, and whatever that value comes out, that will be called market value, even though it is not a proper way of computing market value. It is not market value, but it is for practical purposes. The process so adopted is called computation of or assessment of market rates by a government official. These rates, circle rates, stamp duty rates, registry rates, they generally are below true market value. If, for example, if a property will fetch you 1 crore on the market, according to circle rates, registry rates, its value will be assessed 60 lakhs, 70 lakhs, generally less than less than market value. As a result of this, the compensation that you see a property that will hypothetically fetch you 1 crore, but its value assessed according to circle rates, registry rates, its value will be assessed less than 1 crore. It will be generally 60 to 70 lakhs. So let's now see what happens to you if you lose property. If you lose a property that is worth 1 crore, you lose it to government. Government takes it away. This property, if you sold it to me, I'm a private individual, you would have got 1 crore because you will not sell it at a price below 1 crore. That's the market value. That is what you can get through market channel. But if government takes away this property, you are not going to get 1 crore. What you will get is 60 lakhs, 70 lakhs. So you get compensation that is less than market value. Market value, I argued, is less than the compensation that you want, what will be called just compensation. So that's the nature of the problem. Why people affected by land acquisition, eminent domain, they are left worse off. This is also the reason why we have seen many protests against use of land acquisition laws against eminent domain, because people who got affected by eminent domain, they were left worse off. Even though you can go to court and dispute and ask for higher compensation, but you have to engage in litigation to get higher compensation. Point is that at the time of eminent domain use, you are left worse off. All right. So therefore, we have to ask a question. If eminent domain is problematic, it leaves people worse off. What is the economic justification for eminent domain? We have seen the legal justification. Legal justification
Excuse me, sir. There's one question on the same from Raghav Makkar in the chat box.
So can you please read?
So the question Raghav, is, why is it, or Raghav, you want to ask? Raghav, are you there?
So can you, Hitesh, can you read the question?
The question says that why is it assumed that if the money that I ascribe to my land is equal to the market value, then I would have already sold my land?
Well, strictly speaking, if the value you assign, market value, the monetary worth you assign to your property is 1 crore, and if market offers you 1 crore as its price, strictly speaking, you can still hold on to your property. But if market offered you 1 crore and 1 rupee, then you should sell it, because you will be giving away property, something that is worth 1 crore to you, but you will get more than 1 crore in return. So when two are equal, then I agree you can still hold on to the property, and I appreciate that you have listened to the argument carefully. But main idea is that this tying point aside, the fact that you have not sold your property, it means that what market offers to you is either equal to your valuation of the property or less than. It will be equal only in rare cases. Therefore, generally speaking, when you are holding on to property, market offers you less than the monetary worth you assign to your property. Okay, so this is we are being stickler here. I appreciate that. I hope you got the response.
Yes, sir. Thank you very much.
Sure. Any other questions?
So there is question from
Jasmine,
madam, that why there is difference between circle rate and market rate of property?
Okay, all right. That will be some digression, but I don't mind answering the question. You see, the reason, first of all, there will always be difference between circle rates and market rates of any given property. There will always be. It is humanly impossible to put circle rates equal to market value. Why it is humanly impossible? As I said, circle rates are the decisions, are the rates, assessments made by government officials of properties. Different areas have different circle rates. In a city, posh areas that are considered to be posh generally have higher circle rates, and then less developed areas will have lower circle rates. From city circle, as you go to villages, the further you go from a big city, circle rates will keep on, or registry rates will keep on decreasing. Market value also will behave the same. Post colonies will have highest rates, followed by less developed colonies, followed by less developed villages. So directionally, the two circle rates and market value, they move in one direction, in the same direction. However, market value of property, two properties, think of two adjacent houses, same area, or think of two vacant plots, even though they are same area located on the same road, but still they demand different market value. No two properties command same market value in real world, because many factors affect price of a property. Its exposure, whether how far it is from main road, whether it's east facing, west facing. There are a host of factors that affect market value of a property. No two properties have same market price. But circle rates are same for all properties in a neighborhood. Therefore, circle rates will be different than market value of most of the properties in that neighborhood. Okay? So through that process. But then the question we want to ask is why circle rates are generally lower than market rates? That's the question we should be asking. Circle rates or registry rates are lower than market rates because, after all, decision makers also, they are sensitive to what people feel. In normal times when government is not around divesting us of our property, we want circle rates, registry rates to be low. Why? So as a property owner in any area, we want circle rates, registry rates to be low. Why we want the rates to be low? Well, because when we engage in property transaction, circle rates serve as a reference point for imposing tax. Higher the circle rate, higher will be the tax we pay on the transactions, property related transactions. So in normal times, property owners want circle rates, registry rates, stamp duty rates to be low. That reduces tax burden on them. Problem arises that when same rates, in normal time, we want them to be as low as possible, but when government takes away our property, then they hurt us. Low rates means low compensation also. But I hope I have answered the question why circle rates are in general different from market rates, and why circle rates tend to be lower than market rates in general. The other reason why circle rates tend to be lower than market rates is that circle rates are revised once in 3-4 years. But market rates keep on changing. On that count also, market rates, circle rates are different, but market rates generally tend to move up. Circle rates remain rigid. As a result, the wedge between the two, it keeps on increasing. At times it can be serious. By the way, you might have read that under new land acquisition law that was enacted in 2014, compensation has been enhanced. Compensation for property owners has been raised to simple market value compensation to twice the market value compensation, or up to 4 times of market value compensation. Actually, whenever in land acquisition law you read market value term, you should read it, you should think of circle rates, because circle rates are less than market value to compensate, to make up for the loss suffered by property owners. Government had made compensation equal to twice the circle rates. The idea was that through this process, a compensation will come closer to actual market rates. Okay.
Sir,
Yes.
can we argue that circle rates
Yes, please.
Circle rates are an efficient estimation because they discount for the asset price bubble, and therefore they are inflationary correctional in nature. Can we argue that?
They could be. They play some role in tempering property prices. They play some role, but I don't know if they are efficient. Their only role is, their major role is in the form of tax burden. when we engage in transactions. Actually, they can go in either direction. Suppose think of a property. You own a house that is worth 1 crore. In the area where you own house, suppose circle rates are 8%. 8% of 8. So stamp duty rates are 8% of
Circle rates.
property. Well, so stamp duty rates are suppose 8%. Now, if we go to registrar's office and actually honestly declare that this transaction, this sale has happened in 1 crore, then we will be paying 8 lakhs. 8% of 1 crore would be 8 lakhs as a stamp duty tax will be paid to them. So as opposed to 8%, if stamp duty rates are 10%, then then burden will be additional 2 lakhs. Total tax will be 10 lakhs. So that can dampen my willingness to buy your house, because now your house will cost 1 crore 10 lakhs. So as registry rates go up, they kind of dampen people's tendency to engage in sales and purchases. So they play some role, but I do not know whether they are necessarily efficiency enhancing. They can be efficiency enhancing if circle rates or stamp duty rates are adjusted to market conditions. When policymakers feel that property market is hot, that time if they increased property rates, that time when property market is hot, if that time registry rates, circle rates, if they are increased, that will dampen the transactions, put downward pressure on prices, and vice versa. If they feel that property market is dormant, that time if these rates are reduced, then it can have stabilizing effect on the property market.
Thank you.
But since they remain same, so they do not play that role which they could play in principle.
Thank you.
Okay, all right, that was some digression, interesting digression. Let me now bring your attention back to the economic rationale behind eminent domain. Before we discuss economic rationale behind eminent domain, I want to ask a question. What is the implication of eminent domain for Pareto optimality of transactions? Does use of eminent domain lead to Pareto superior outcome? Now here, some participants may not be familiar with the term Pareto optimality or Pareto superiority, but we can discuss that. I can explain the idea of Pareto superiority optimality is ascribed to Alfred Pareto, an Italian economist, political scientist, philosopher. So the basic idea behind Pareto optimality is that people involved, none of the people involved should get adversely affected. Go back to apply this idea, go back to our initial setting where you own a property, I want to buy it. If you agree to sell your property to me voluntarily, you will agree to sell your property only if I offer you a price that is higher than your valuation of your property. So if this deal between you and me goes through, you will get price and I will get your property. Both of us will benefit from this transaction because you value money that I am offering you more than the property. Sorry, please keep muted. Unless you have to ask a question, please keep muted. So in any transaction, including property transaction, the seller becomes better off sellers benefit from transaction because seller gets a price that is more than his valuation of what he or she is selling. Buyer also benefit because buyer gets something that is more valuable to him, more valuable than price he is paying. This is the nature of each and every voluntary transaction. That's why transaction, trade, exchanges are good. They make both parties better off. They harm no party. Generally, they benefit both sides or all sides of any transaction. The process of these parties becoming better off, we call this process as a Pareto improving outcomes. Pareto in the sense that all parties get better off. This will be the case if you sold your property voluntarily to me or to government, if you sold it voluntarily. But if government takes away your property by force, if your consent is not important, then Pareto optimality, Pareto superiority of the outcome is not guaranteed. Government may take away your property worth 1 crore and give you compensation only 60 lakhs, 90 lakhs, 95 lakhs, 99 lakhs. As long as it is less than your valuation of your property, you will not become better off. As you do not become better off, this transaction, it's unfair to call it transaction, but the process of transferring land from your hands to someone else's hand will not be Pareto improving. So then I will skip the third question here, but I will take the last question. Does efficiency of eminent domain use depend on compensation? Yes, it depends on compensation. If your property is worth 1 crore in your view, and you get 1 crore of compensation, then and government uses that property to do something that is more valuable, then everybody involved will benefit from the process. So compensation can make the process efficient. In contrast, if government pays you less than what you value, your valuation of your property, then the Pareto efficiency, Pareto optimality is not guaranteed. Okay. So let's now discuss some other rationales. One of the rationales I provided for eminent domain use is that it is to allow government to follow public purpose activities. So something, if government is doing something in larger public interest, then it's okay to use eminent domain power. Question we want to ask is it really necessary for government to use power just because government is doing something that is in public interest? Does public interest justify use of force to take away private property? Answer is no. Why? Think of well-meaning government, politicians, bureaucrats, policymakers. Suppose they are all well-meaning, they want to fulfill, they want to make decisions to enhance social welfare. In that process, suppose they want to connect villages with roads or widen existing roads, they want to open new schools, universities, and for that they need land. So land will be used for eminent domain, will be used for public purpose only. But in all such examples, to make a road, to make a university, open a hospital or a school, you need land, but you also need other factors of production. You need labor, you also need money, capital. And government never forces people to work because they are building a university, they are building a village road. They also do not force people to part away with their savings, with their money, because government has undertaken something that is in public interest. So when it comes to factors of production, land and labor and capital, government does not force people. Then why people should be forced for the other factor of production, which is land? So the public purpose in itself cannot justify use of force. Remember, eminent domain involves coercion. It involves use of force by government, because if government is building road, you are free to work on that road and get paid for your labor services. But you are not free if government needs your land to build the road. Okay? So you see the distinction. The question we are asking is why this distinction is there in the case of land. Public purpose per se does not justify this. Then justification has to come from some other perspectives, and that perspective is the land assembly problem. Unlike assembling labor and capital, land assembly is assembling land is a different, very different matter. So when it comes to building a road, then villagers from nearby villages can supply labor, but people from other places also can come and work on the project site and supply labor. So labor aggregation problem is not there. Similarly, government can use local resources, local capital, or can borrow from Reserve Bank of India, can borrow from market and use that capital to build road. Does government have similar liberty when it comes to making provisions for land? Answer is no. In most cases, answer is no. Think of roads. On a road building, any two individuals can work as laborers, but not any acres of land will serve the purpose. To build a road, you need land in contiguity. Adjacent parcels of land are needed. That is the case for all linear projects, road, railways, ports, canal projects, power line projects, for instance. They need adjacent land for projects to take off. Big industrial projects also need contiguous land. The contiguity requirement for big projects, for linear project, makes land as a very different factor of production compared to labor and capital. When it comes to when you want to launch a project, therefore you want to secure contiguous land parcels, then several things, several challenges have to be dealt with. One is that you have to negotiate with adjacent. You have to make sure that if I sell land if I give away land for my land for a project, then my neighbor also has to give her land for the project. Her neighbor also has to, and all this process, just persuading people to part with their land can itself becomes very costly. The transaction cost of doing so can be very high. As a result, what is called cost theorem can fail in the transaction cost, or putting all the lands together can be very costly, time consuming, effort consuming, and it can delay the project. So we call those costs as a transaction costs. So transaction costs are unusually high when we have to secure contiguous land. The related problem is that some property owners may want to act strategically. They can demand price way higher than their valuation of their property. Okay. So I want to say more on the last point by way of example, but let me pause here and see if you have questions.
Sir, why you said that the public goods argument, it's okay, but beyond that also this argument required for the eminent domain. So don't you think public good itself take care of the overall, because other arguments are only explaining the social benefit, overall public benefit, and then justifying the eminent domain.
So my point is that in the name of public good, public interest, when you do not force labor as a factor of production to work on project site, when you do not force banks or money lenders to lend for the project, why do you force property owners to give their land or property for that project? If public interest, if public good, public interest was justifying, was the rationale, then this rationale should apply to labor and also capital. It does not apply in real world. Why it does not apply to labor and capital? Why it applies to third factor of production, which is land? So the public good requirement does not provide adequate justification for forcing people to part with their land. That's my point. It has to be something more than public good. Public good is perhaps a necessary condition, but it is not a sufficient condition for people to be forced into giving away their land. Remember the legal principle of eminent domain, our Land Acquisition Act of 1894, even our Land Acquisition, Settlement and Rehabilitation Act of 2014, they force people to part with land, their property, under some circumstances. What are the reasons why law, legal orders throughout the world, they force people to part with their property? It cannot be justified in the name of public interest. Public interest is a desirable qualification for a project, but it is not sufficient enough. Because if it was sufficient, then you should apply same standards with respect to other factors of production, labor and capital. Okay, all right. Moving on, I am going to provide you economic
There is
justification
one,
behind.
question is there, is from Akshay Thakre. Can sovereignty come under the ambit of eminent domain when it comes to assembly of land?
So sovereignty of the state, I don't know, I am not sure if I have understood the question, but if question is that whether the sovereign, which is the state, can act as a sovereign, as a supreme owner of property when it comes to land assembly, can it come in for contiguous land? Answer is yes, it comes in there. And it comes wherever when land required is contiguous or not. Under eminent domain, as long as government says that it is taking away private property in the name of public purpose, then contiguity, non-contiguity, the sovereign, the state agencies acting as a sovereign exercise their power as a supreme ultimate owner of property. So we say that, you know, some countries, socialist countries, in socialist countries, people do not have property rights. The state has the ultimate property rights. Basically, the same idea plays out through eminent domain laws in you know, democratic or market economies also. The state agencies use eminent domain law to act as a supreme ultimate owner of a property. So is there Pratik Kumar has a question? What is the question? Can you read out?
Is it safe to assume that in every case of land, assembly requirement Coase theorem would suggest use of eminent domain?
So we will discuss this. Let me give you some insights into this dimension, and then we will discuss this question. So I want you to, so since it's a workshop on law and economics, economic analysis of law, or providing economic foundations of law. So here, my argument is going to be, I will provide economic justification for eminent domain use. In today's lecture, So I will argue that eminent domain laws are primarily driven, motivated by the primary foundations are economic in nature. So let me try to argue. So in next 5-10 minutes, I will be using some symbols. Please do not get discouraged if just because you see a symbol. I will use symbol and a number related to that symbol. So try to be with me. Again, feel free to ask questions. Now, for next 10 minutes to ask questions, you don't really have to type them. You can simply unmute yourself if you can and ask the question or type them in the chat box. So that it's very important for me that you get the nature of the argument. I want you to think of a situation, simple situation, where one buyer, the buyer could be government, it could be private developer, wants to buy 2 acres of land. So we can extend the nature of number of acres, but to convey the idea, it's enough to consider just 2 acres of land. So think of yourself. I want you to think of yourself as a buyer or government official who does not want to use eminent domain, but wants to buy land through private voluntary transactions. You need 2 acres for your project if you are a project developer, or you need 2 acres of land, and these acres have to be contiguous because you are building a hospital or you are building road. So the contiguity has to be there, 2 acres. For simplicity, only to keep things simple, assume that 2 acres are identical in all respect. If buyer B is buyer, that is you are eyeing 2 acres, and if you can buy them together, then you can launch a project that will give you, that will be worth 100 to you. You will be able to make profit of 100 if you can use both the acres simultaneously. Your project is big, so you need both acres. If you have only one parcel, 1 acre, then it's not good, it's useless for you. 1 acre is useless for you, 2 acres serve your purpose. If you have both acres, you can make profit of 100. 1 acre is worth only 40. You can think of small v, capital V, as the value of the project. If project takes off, small v is you can think of market value of 1 acre of land. 1 acre of land will get market value 40. So that's what for you. Also, you don't care about land as such. Its market value is 40, so you also value it 40. Standalone acre is worth 40 for you. Okay. Now, so this land is not your land. You have to. This land is owned by 2 farmers, 2 property owners, 2 farmers. One farmer owns 1 acre at R. R is the reserve price, which is 45. So I am one of the farmers. So I value my acre at 45. There are 2 farmers. There are 2 of us around. I am one of the 2 farmers. So as a result, this land in our hand is worth 90 as per our opinion. This land is worth 90 for us, but if these 2 acres go in your hand, then you can use them better. We are farmers, we do only agriculture. You can launch a project and project will generate higher profit. So this land is worth 2 acres are worth 100 in your opinion, in your valuation. So this is a situation where industry can come up on agricultural land. Industry will be more valuable, worth 100. In its current use, the land is worth 90 for these 2 farmers put together, and market value of this land is only 80, 40 per acre. Is that clear? So that is the situation we have got. Now question is, just since I value it more than you, I should be able to buy it from two farmers. You should be able to buy it from me and my neighbor who is also a farmer. Question is, if you want to do that, what price you will have to pay to us? It is clear that, since I value my land at 45, I am not going to accept a price less than 45. You will have to pay me more than 45. Okay. I want to take an aside. I want to ask you that if we were to reverse these roles, if I become the buyer and you become the seller, you are one of the farmers, and you know that I need both acres for my project. Would you want to be the first person to sell your land to me, or you will wait for your neighbor to sell his land to me?
I'll wait.
Who will wait? How many of you will wait, and how many of you would want the first one to be to sell the land to the developer? I think most of you would be inclined to wait. And why you would be inclined to wait is perhaps a feeling
So
that
it
you
gives
may get a
me,
better deal.
yes, sir.
You may get a better deal if you wait. That's what actually happens. So let me take you through the dynamics of how it will happen. Let me give you the basic idea first, and then, so if you wait till your neighbor, so suppose your neighbor has sold his land to me. I am the developer. I have bought land of the other farmer. Once I have paid the other farmer price and bought his land, then you know that I am at your mercy. My project cannot start without your land. So you know that I am at your mercy. Why am I at your mercy? So as a developer, I paid a price more than 45 to your neighbor. Your neighbor who is a farmer will demand at least 45. Suppose I paid him 46. I paid him 46 for 1 acre. If you do not give me your acre, then this 1 acre is useless for me. All I can do is sell it on market, and that will get me only 40. I will end up incurring a loss. You know this, that if you do not sell your acre to me, then this developer is looking at loss. He will have to abandon his project. You would be tempted to exploit situation and ask for a higher price. So this is the idea I will try to capture. So we want to consider a situation where I have bought the first acre, and you are the second owner. I have come knocking at your door. If the deal with second owner, which is you are the second owner, if it does not go through, then I will end up with an acre that is worth only 40 to me. Second, for you, if the deal does not go through, then you are still holding on to 45. That's worth value of your property in your opinion. However, if the deal goes through, then what will you get? If the deal goes through, what will I get as a developer? I will be able to launch a project that is worth V100 in my opinion by paying a price P2. P2 is the price I will pay to you, the second owner. So it turns out that if the deal between you and me go through, what will my gain be? The developer will earn capital V. Please keep your attention where you see the cursor. For the developer, successful deal with second owner, that is you, would mean I will earn V, capital V, at a cost of small v minus P2. and you will lose R, that is your reserved price 45, but you will get a price. If we add these two together, then the second deal is going to be worth V minus R, which is that between you and me, if the deal goes through, there'll be net gain, net profit of 15. You would want at least half of that. You may say that, if I sell you my land, the net profit you are looking at is 15. Give me at least half of that. Half of that will turn out to be, let me bring your attention here. You will not sell your property, your acre, less than 45, because in your opinion, it's worth 45. Plus you will get half of the profit that I'm looking at. So you will demand the price 52.5. It doesn't have to be 52.5. The basic idea is that knowing that I'm at your mercy, knowing that I will incur a loss, if you do not sell your land to me, you will be able to extract a higher price. So by waiting, you will get a higher price than the price first seller will get. This process is called holdout process or hold-up process. What it does is that even though, if this contiguity requirement was not there, you would have sold your property if you knew that I am not at your mercy, and you would have sold your property at a price of 46 because you value it at 45. Anything higher than this, you will be willing to sell. So you perhaps will sell at a 46, 47, but now once you realize that I have made investment in the project, I become at your mercy, you charge higher price. This higher price increases project cost. As a result, it renders project less profitable. In several situations, if you become unreasonably demanding, then you may demand a price that I cannot afford, and I will then have to abandon that project. So that is the nature of problem. Eminent domain laws are basic motivation of eminent domain. Just ignore that. The basic motivation of eminent domain laws is to overcome this problem. This logic applies to big private projects and also big public projects. It applies wherever contiguity of land has to be there. That is the main motivation behind main economic rationale. This is the main economic analysis of eminent domain law. It is supposed to overcome the problem of anti-common. So what happens? If eminent domain laws are not there, then many projects will get stuck because people will demand too high price, especially the sellers who volunteer to sell later on. They will demand very high price. Many projects will get stuck. Very few projects will take off. Excuse me. So we call this problem as the tragedy of anti-common. To put it in perspective, you might have heard of tragedy of common. Elinor Ostrom, who was a political scientist come economist, who got Nobel Prize for her work in dealing with for her research on how people deal with tragedy of commons. Tragedy of commons deals with the issue where there is over exploitation of resources. But eminent domain says that in the absence of eminent domain, there will be underutilization of resources, which is land. So to overcome the problem of anti-common in case of land, the problem is not tragedy of common, it is the tragedy of anti-common. Land will not be overused, it will be underused in the absence of eminent domain. So to overcome that problem, we have eminent domain law. Same logic applies in case of patents also. The patent laws, intellectual property rights, they are also, the provisions like compulsory licensing. Their main justification is, their main economic rationale is to be able to overcome the problem of the tragedy of anti-common. Aggregation, wherever aggregation problem arises, there has to be a law to deal with it. So the land assembly requirement, contiguity requirement, provides sufficient condition for economic justification of eminent domain use. It provides economic justification. However, eminent domain in itself does not guarantee efficient use of resources. It does not guarantee efficient use of resources, because in our example, your property is worth 45 to each farmer, but if government takes away this property by paying compensation of 40 or 30, then these people will be left worse off. Moreover, government can launch suboptimum projects. Suppose a project whose social value is only 80, government can launch that project, because if government can get away by paying compensation that will cost less than 80. If government pays only 30 to each farmer by way of compensation, then this land will cost only 60. And on something that costs 60, you can take up something that is worth 80. Even though 80 will leave society worse off, but government can still, governments at times still misuse eminent domain law, pay less compensation, and they launch inefficient projects. This problem arises mostly in case of private projects. At times you find race courses built close to where there are no schools, where schools are needed, instead of building more schools, hospitals, or extending road network. Government agencies choose to provide race course or 5-star hotels. So those are instances of misuse of eminent domain law. So I will stop here. I will let you ask questions. So I would say that, I have tried to give you a simple example for land assembly problem, holdout problem. But if you find it too technical, it's okay. But do try to attempt to understand it. Up to this slide, you should try to understand it. Here there is a typo here. It should be actually there is a typo here. It should be 46.25. So this is erroneous. It should be 46.25. Other than that, try to get as much as you can from this. All right. Questions?
So can we say that this eminent domains provide a project becoming viable with circle rate?
Yes, it makes project viable by reducing land cost. But problem is that eminent domain can make projects viable that are not in social interest. That also the other side of the same coin. It makes projects viable, all types of projects viable. However, from social viewpoint, we want to make only socially desirable projects as viable. We don't want socially undesirable projects to become commercially viable. Problem with the eminent domain is that it can make socially undesirable projects also commercially viable. So wherever land comes cheap through eminent domain, you see private companies, they rush to make investment.
Sir, may I ask a question?
Yes, please.
Sir, when you say that it will make socially undesirable projects viable, How do you decide what is socially desirable and what is socially undesirable? Like what may be desirable to me may not be undesirable to you.
That's very fair point. There are two ways of looking at how to assess. In today's lecture, I have not dealt with the issue of how to determine whether a project is socially desirable or not. Hopefully, I will talk about this issue in tomorrow's lecture. But I want to give something for you to think about. One way to assess, one way to decide whether a project is socially desirable or not is through legal and political processes, where either people in an area, project affected people vote, and then you have political institutions to decide either you go by the majority or by 2/3 majority, 3/4 majority. That would be one way to assess social desirability of a project. Other, where we use primarily utilitarian principle would be that we undertake what is called project impact assessment exercises, and there are well laid out processes how to go for project impact assessment, environmental assessment included, but affect how a project is going to affect lives and livelihood. You document the cost, you also document the benefits, and then you take a call whether the project seems in social interest or not. So these are the processes that are laid out, and we can have a different views, of course, on any project. A project, so that will come next to your house. Think of urban, excuse me. So think of an urban development project, so people. Can I take up this question next? So there's a background noise that I don't want this lecture to be affected by. But if you can ignore the background noise, do you hear something other than my voice?
No, sir. And
Okay, good.
you
All right.
answered like most of my question.
So you may have, we may have different view. For example, if a water treatment plant comes up next to your house, or a hospital comes up next to your house in an urban setting, you may not like that. It will lead to congestions for you, but it may benefit it will benefit other residents. So in such situation, both utilitarian principle as well as cost-based, as well as political institutions, if we adopt, they will lead to recommendation that let's have a hospital. So such decisions are not guided by unanimity. They are driven either through consensus, if we adopt political institutions to make decisions, or cost-benefit analysis in terms of the benefits of additional number of lives saved, what are the benefits for each life saved or each life elongated. So through these processes, we will have a project impact assessment and take call.
All right.
Any other? All right, then that's the time we stop. Okay, I will see you tomorrow.
Thank you, Professor Ram Singh.
Sure.
Thank you very much.
Sure.